parts. The first part, I will be discussing about bilateral investment treaties that has been concluded by Ethiopia, and what are the main features, and what are the main principles of international investment law that was incorporated in these BITs. That's the first part. And then the second part, Martha, who you know very well, should be joining us to discuss what are the latest trends and how has the adoption of bilateral investment treaties has evolved over the years as a matter of policy. So she'll be sharing with us what are the latest trends and developments. Has there been any lessons that we've learned as a country in being able to have a very modern or standard bilateral investment treaties? So she'll be joining us at 9:30. But before that, I will discuss simply what are the general provisions of the BIT that we have concluded so far. So you'd recall last week we discussed about the evolution and origin of international investment law and how it has evolved over the last 100 years. We also discussed about the Calvo principle, which is advocated by mostly developing countries, and the Hull formula that was developed by the Secretary of State of the US that is quite advocated by the developed countries or Western nations. We also discussed about the sources of international investment law and the main principles of international law, mainly the national treatment of investors, the MFN treatment. We also discussed about the fair and equitable treatment and the compensation and expropriation principles. And finally, we discussed about what were the regional and international efforts that were there to really codify international investment law. So we went through all that process, and the conclusion, if you recall, was that we really do not have any international or supranational body of law that regulates international investment law. There were efforts at the regional and bilateral level, but nothing that exists as one convention that regulates international investment law. So within that context, we will come to bilateral investment treaties. So the bilateral investment treaties sort of came about in response to the lack of a universal law that existed, that did not exist at the time. So while countries were trying to determine how their investments were going to be regulated, they were trying to come up with regional instruments, with international instruments. Individual countries began their own efforts to regulate their individual investment in individual countries. So this was started by Germany in 1950. So Germany was the first country to initiate. As you know, Germany during the First World War and the Second World War was the main actor that sort of lost a lot of its investments in other countries. So while a lot of efforts were going on in the UN, which really did not go anywhere, so Germany came up and said, okay, we need to do something about our own investments, so why don't we try negotiating bilaterally with governments. So Germany initiated this effort and went around individual countries to come up with a bilateral treaty. So that started in the 1950s, and then quickly, once Germany started signing on these bilateral investment treaties, it was picked up by other developed countries, which were not very happy, as we saw last week, on how the developing countries, especially the Latin American countries, were being very protectionist in trying to protect their own investments. So the effort that Germany was going about was picked up by the UK and the US, and through these bilateral investment treaties, what these developed countries were trying to do was really insert provisions that protected their own interests, primarily the Hull formula around compensation payment and expropriation rules. So it was a roundabout way of developed countries protecting their own interests in other developing nations. And one of the ways they did this was by sort of linking the developing countries' ability to attract investment with that of signing of a BIT. So basically, they were saying if we are nationals, or if the country has signed on a BIT, then that will be used as an instrument to attract more investment. So they sort of used it as a mechanism whereby they were forcing countries to really sign on to this agreement so that they would be able to invest. And in a way that was a reasonable position for them to hold on, because BITs offered a really strong protection for those investing countries, for the capital exporting countries in terms of their investments being protected. All of the principles we discussed last week were incorporated in the BIT. So one by one, countries started signing on to the agreement so that they would be able to attract investment. And this was picked up by other countries. Like I said, UK and the US started picking up until the 1990s. And then once the fall of communism came about, all the efforts that the developing countries were making in the UN and other regional instruments were almost abandoned by that point, because there was this really stiff competition for investment. You know, countries that had socialist policies were falling apart. There were economic challenges in many countries, and they really needed to spur investment in order to spur foreign investment in order to have their local economies. So by the 1990s, and with the triumph of capitalism, what happened was countries started signing on bilateral investment treaties in mass. So there was a very, very clear competition between many developing countries to have foreign Western countries come in and sign the BIT. So there was a clear sort of trend towards, in favor of Western countries, which really were frustrated at the UN level and at the regional level to be able to bring on this international convention, and they sort of won through having a lot of countries sign on BITs. And this is because BITs provide safeguards for non-commercial risk. You know, when investors go into the country, there are commercial risks and there are non-commercial risks. So the commercial risks are, does my investment make sense? Will I be able to make profit out of it? Is there enough market in that country for me to be able to, you know, have the return on my investment? These are the commercial considerations that investments make. But in addition to the commercial considerations, the main and really critical aspect of any investments are the non-commercial risks. These are political risks, for example. Is the country stable enough for me to invest in? Will I be able to repatriate the money I've made outside of the country? If there's a dispute between me and the state, or me and another investment, will I be able to have a fair recourse to those disputes? So these are non-commercial risks that are quite separate from whether that investment makes a business case or not. And these are mostly safeguarded through bilateral investment treaties and all of the principles and the provisions that we've seen. So for a lot of investors, it was a matter of confidence in that if the country where that investor originates from has a BIT with the country that's being invested on, then that gives a big confidence to the investor that his or her investment will be able to have the minimum safeguard that is needed. So with that trend, currently, there are more than 3,000 bilateral investment treaties in the world. Huge body of law and a huge source of international investment law, where many, many countries have really signed on this instrument in the last 20 years. When we come to our country, we have the latest information I have is we have 35 bilateral investment treaties that Ethiopia has signed on to. Some of them are fully effective, some of them are not yet effective. By effectiveness, I mean that they've signed it on, but it has not been yet ratified by Parliament. So, but at least there are 35 investment treaties that we have signed on. And this is another source of international law that, in the absence of a convention that regulates international investment law, BITs come in and fill that gap. So whenever there is any dispute between the investor and the investment, the BITs would be a source of law that the courts or the arbitral committee would look into. So when we look into the BITs, what are the main contents? They follow quite a standard format, many of the BITs. They're not identical, but they follow quite a standard format. They would have definitions. The two important definitions, they would have definitions. I'll come back to that. They would have a duration. How long is the BIT in force for? What is the duration of the investment? And what are, once that duration terminates, how is it going to be extended? Is the second one. And what is the scope of application? How, to what extent will it be, applied? Will it be before investment, during investment, or after investment? The scope scope of application is the second content. The third one is the standards of treatment. Obviously, this is a very important part of a BIT and also international investment law, as we saw last week. What are the standards of treatment that the country, the host country and the home country will offer in terms of national treatment, MFN and fair and equitable treatment. And then lastly, what are the dispute resolution mechanisms? So if there is any dispute between the investor and the state, or even between the state and the state, and or even between two different investors, what dispute resolution would be pursued. So this is a typical content of a BIT. So when we come to the first part, definition is very key. So BITs typically protect the investment and also the investor. So how investment is defined and how the investor is defined is critical, because it determines whether that investment and whether that investor is actually protected by the BIT. So if say one investment or investor does not fall within the BIT, then it loses its protection. So when we come to the definition of investment, last week you recall we saw that how international investment law understands investment. The way the concept evolved was it understood it only as a direct investment, where one country goes in and invests equipment, capital, and physical assets into that country, and it did not really incorporate portfolio investments where shares were bought, stocks were exchanged, debentures and other documentary instruments were used as a way of investor. The way the concept evolved, but now currently when we see the definition of investment, it's quite broad. I'll give you one example between the BIT that was signed between Ethiopia and Israel, for example. Defines investment as any investment that includes movable and immovable property, as well as other rights in rent. Rights derived from stocks, shares, bonds, and debentures, and other similar investors. Claims in money, claims in goodwill, and other assets of performance having economic value. IP rights, copyrights, trademarks, industrial designs, and other similar rights. And also concession rights or concession contracts. So for example, if one investor has an agreement with the government to explore, for example, oil, that agreement in itself would be considered as an investment. And anything that comes out of that agreement, whether that investor invested in that plant or not, will be considered as an investment. So you'll see that this is a very, very broad understanding of investment and what it encapsulates. But countries have made effort to restrict it in a way that this is not a blanket rule. There are two ways in which the definition of investment is qualified. One is the definition that is given under the BIT would have to be interpreted in accordance with the law of the host state. Meaning, to the extent that those definitions, the ones that I all listed, are recognized under the national laws, will they be recognized as an investment? So say if in Ethiopia, for example, the rights to IPs and copyrights are not recognized under national laws as an investment, or they cannot be considered in cash or in kind or as a matter of investment are not recognized, then irrespective of the fact that they're listed on the BIT, they still will not be considered as an investment. So countries sort of try to qualify what it means an investment by really subjecting these rules to their own domestic laws. That's one. Secondly, the other way that the definition of investment is restricted is by making it exhaustive in the sense. Some BITs only put these lists as an illustrative. They say anything that is that includes this list but not limited to this list would give it as an illustrative list, in the sense that although it's not listed in there, if it's similar or it could be interpreted in a similar way, then other investments can also be included. But those countries that are quite cautious and want to really limit the protection of the BAT. They would say that all this list is only exhaustive. Anything that's not listed in the definition of investment will not be subject to the interpretation of the BAT. So these are the two ways. So when we look at the Ethiopia's BAT, we see that both have been adopted. Some of the BATs that we have, in fact, most of the BATs that we have would qualify investment as those that are subject to the interpretation of the domestic law. So to the extent that our investment laws or other relevant laws, such as the Commercial Code or the Commercial Registration and Licensing Proclamation, defines investment as any of those that are listed in the BAT, then that will be considered as an investment. If it's not, then it's not. And most of them are illustrative in terms of the listing. They're not exhaustive. And it's sort of a combination of, subjecting the laws to the domestic interpretation and adopting an illustrative list that we see in a lot of the BATs. You'll also be able to see in your readings of these BATs what Ethiopia has adopted when it defines investment. And secondly, the most important part of a BAT and a definition of investment is dispute resolution. You would also see in the BATs that you read that if there is any dispute that occurs between the host state and the investor, the dispute resolution clause would say if they result to an arbitration under the ICSID Center, which last week we discussed was hosted by the World Bank, then that ICSID Center has its own convention, which the convention established the center. That convention has its own definition of investment. It says any dispute that comes that is being entertained by the ICSID Center will have this definition of investment, and the convention has its own investment definition, whereas the BAT also would have its own definition of investment. So any dispute that goes into the center, the question is which definition of investment will be entertained. Should we use the one that is in the BAT, or should it be the one that is in the convention? So this is something that has been tribunals have sort of grappled with when they try to really interpret disputes that come into the center. And there has not been a consistent way in which they have determined which investment definition should be used. But to the most extent, they have used that those parties who have consented to the center have also consented to the use of the convention as a way of interpretation. So they've tilted towards using the definition of the convention when they entertain their cases, in addition to that provided by the BAT. So probably as a question I could raise. So we talked about all the movable, immovable property, the shares, the bonds, and the debentures. But say there is an investor comes into the country, before it invests into the country, commits its resources, comes in for a feasibility study. Say if it's a mining company that is looking to invest in the mining sector, in the gold, it needs to know whether the gold actually exists first before it's able to invest. So spends millions of dollars on looking and exploring for the gold. And it determines that there is gold and decides to invest. Say there's $10 million was used for the exploration. Then company comes in and decides to invest and puts in another $10 million to actually set up the plant, the mining plant. So would the first $10 million be considered as an investment for the purpose of the BAT? Or will the company only find protection after it has decided to invest and set up its own plant? Is the feasibility study and the exploration in the pre-investment stage, should that be considered as an investment for the purpose of the investment extent that there is a post-investment, then the protection will also apply to the pre-investment stage up to the post-investment stage. And it should be on a case-by-case basis.
A case-by-case basis, the compromise is the post-investment country. And to make it a bit more clear, I think in the BIP, it would be nice if there was such a provision included to indicate what would apply to the pre-investment stage out of the provision.
Okay. Yes. Okay. So now the issue would come. Say if there's any dispute, and let's say if the government goes on and expropriates or nationalizes this mineral plant, and when the investor claims compensation for that plant, will it use the pre-investment, the feasibility study, the investment that it has put on for the feasibility study, the $10 million, and the one that is also used for the actual investment? So will the investor be entitled to the entire $20 million, or will it be only entitled to the $10 million it spent after the project was set up? So these are some of the questions that really come into when disputes arise, and whether the BIT applies to which investment, at which stage, and to which investor. So a lot of different BITs have adopted different ways. Most of them would argue that the BIT would only apply after the investment has been made, that the pre-investment that goes into the investor as part of the commercial risk that any investor goes into when it tries to invest in a host country. But there are some also other BITs that are quite generous and also incorporate pre-investment of the investor to be able to give protection to the investor. So there are different ways, but when it comes to Ethiopia, most of it is post-investment. And then secondly, another definitional aspect that we look into in a BIT is who is an investor. So we said that the investment is protected. Not all investments are protected. To the extent that they fall under the national law and the definition of the BIT, they will be protected. But the second determination is who is the investor. So there are two types of investors. Yes, go ahead. For example, when we talk about the investment in the mining sector, in order to do the drilling, you need the equipment, you need to hire people, the local population, and you need to invest a lot of capital into the country. So they would say, although it's a pre-investment stage, although we have not gotten any benefit out of it, but we've still injected money into the country. We've brought in the equipment, we brought in the money, and we also hired local staff in order to do this feasibility. So in terms of the investment, what the country has benefited from, even though we have not received any return on the investment, we still have benefited the country, and therefore we're entitled to the protection that it gives. And we will also look into this when we discuss our investment law in the coming weeks, which sort of distinguishes phases of investment. There is the project phase, and there is the implementation phase. When any investor comes into the country, and when they undertake a project, first they set up, for example, if it's a manufacturing plant, they set up the plant, they build the factory, they hire local staff, and they bring in equipment from abroad, and they actually set up the actual industry before they go into the business. This could take 1 year, 2 years, sometimes it might even take 5 years if it's a big industry. For example, cement industry, actually building a cement plant might take up to 5 years. That is after the 5 years that they actually start selling the cement. And in which case they will need to obtain a different license. For the duration of the first 5 years, they only operate on an investment permit basis. They're not making any money. They're only investing until the plant itself materializes. So does that mean that they're not protected? They are, because they have come into the country, they've obtained an investment permit, and they're injecting capital into the country. And say, after they complete the project phase, and before they go into the implementation phase and actually start selling, if the government comes in and takes over the investment for any public purposes, then they'll still be entitled to compensation based on that knowledge. So that's that. So on the definition of investors, we're running out of time. So we have quickly go run through it. So there are two types of investments. Like as we know, also in the civil code, there's the natural persons and the juridical person. So natural person, an individual can come in and invest. So individual is the natural person, or it could be a company. In most investments in many countries, especially these days, individuals do not come in, they're mostly juridical person. But if an investor as an individual wants to come in, what is the determination? Do we use his nationality for the purpose of the BIT? Or do we use his residency? Permanent residency. Say if Ethiopia has a BIT with Kenya, if a Kenyan person, if a Kenyan national comes and invests, is it his nationality or the fact that he's not a Kenyan, but he's lived in Kenya for 30 years and has a permanent residency? Which protection would that investor get under the BIT? So there are different, both are adopted in different BITs. Most use the nationality, even if he's Kenyan, but does not live in Kenya and lives in Dubai for many, many years, and invests in Ethiopia, he will be able to benefit from the BIT between Ethiopia and Kenya just because he's Kenyan, although he doesn't live in Kenya. And another way is he's not Kenyan, say he's Indian, but he lives in Kenya, has lived all his life in Kenya, but does not have the Kenyan nationality, and invests from Kenya to Ethiopia, and wants to benefit from the BIT between Ethiopia and Kenya. Would he be able to benefit because he's a permanent resident of Kenya, although he's Indian, and also the investment comes from Kenya? That's the residency test. So again, this differs from BIT to BIT. Most use the nationality. Some quite favorable. They also allow permanent residents of a certain country to benefit. And some use both. Some say you need to be a national of this country, but you also need to have a link, some sort of a link with the country in which the BIT is signed on. So say, if it's a Kenyan national, but lives in Dubai, has no connection with Kenya, the investment was made from Dubai, and wants to benefit from the BIT in Kenya, the BIT would say, we need to see a link between you and Kenya, because the BIT is meant to benefit the investment flow from Kenya. So if there is a genuine link between the Kenyan national and Kenya as a country, then the BIT would be able to provide the protection. So these are the variations that are there, either nationality, residency, or a combination of both. And you will see this also in the BITs that we have signed. Secondly, juridical persons. This is a bit of a complicated one. Juridical persons could come in many different forms. They could be private limited companies, shared companies. Some BITs also include NGOs. Social enterprises. Social enterprises are companies that combine investment or commercial entity with that of a social cause. They're there to make money, but the money would go into providing social services. So social enterprises, stock exchange, traded stock exchange, and all of that can be considered as juridical companies, legal personnel. But how do we determine what the nationality of that juridical person is, or how do we define it? So there are different tests. One is some BITs use the place of incorporation of the company, would be considered the nationality, or the place of incorporation will determine whether that company falls under the BIT. So say if it's in Dubai, and Ethiopia and UAE have a BIT, then automatically that investor who has incorporated in Dubai would find protection under the BIT. Some countries say the nationality of the shareholders. The company is incorporated in Dubai, not from UAE, then they will not be protected. So the nationality of the shareholders, the owners of the company, will also have to fall on the nationality of the contracting state of the BAT. The other one is the effective control. Effective control means who controls the company. Effective control could be differs from country to country. Those shareholders that have more than 50% shareholding. Some countries say effective control can be seen when shareholders control more than 75% of the company. To the extent that the effective control is done by nationals of the BAT contracting state, then that company would be considered as a BAT state. And the final one is the place of business. Say a company, the Dubai company was set up, registered in Dubai, but the business is not there, the business is in London, because that's where the business is run. So it's the London entity which operations are in London that is coming in and investing in Ethiopia. So although that its place of incorporation is in Dubai, but its actual place of investment and where the investment is coming from is from London, then in order to get that protection, then you need a BAT with the UK and not with the UAE. So this can be a very complicated matter. We can, for example, raise the example of Kenya that I mentioned earlier, in which case, say the company was set up in Dubai. The shareholders are Kenyans, not all of them. 75% of them are Kenyan of the company, 25% are, say, Chinese. Shareholders are half, 75 Kenyan, 25 Chinese. Company was set up in Dubai, registered in Dubai. Its headquarters are in London. Headquartered in London. And its main business is in Kenya. Its place of business is Kenya. So when you look at this four determination, all four could be different. The place could be incorporated, especially in this time where a lot of trading is done globally. Some countries are incorporated, most countries are incorporated, for example, most investments would choose to incorporate in countries like Dubai, Seychelles, and Mauritius because they provide very good tax havens for new companies that are set up. Although there are US companies or their businesses is in London, the company that they would set up to invest in Ethiopia would come from Dubai or from Seychelles. And these companies, the shareholders, could be Russians or Saudis. Their business is done in London, their company is set up in Dubai, and the shareholders are different. So how do we know whether they're protected by the BAT that was signed between, say, Ethiopia and Kenya? Do we look at their nationalities of the shareholders? What if there are thousands of shareholders? What if it cannot be determined which investor is the majority investor, or which even has an effective control? What if the investor changes? I could be a shareholder today, and I could sell my share and go the next day. So you look into the BATs, and they try to define this as specifically. Some say it has to be incorporated in the country where the BAT was signed. Some would say that the nationalists of the owners of the company have to come to the country that was signed, where the BAT was signed, and some would have a combination of these. So this is the test that needs to go into when really trying to determine whether that company that has set up its shop in the country of the BAT falls into the investor definition that the BAT has. And then when you look into the BATs, some BATs only protect investments, and some only protect investors, and some protect both. So as you read through a BAT and read into the definition of who is being protected, you would really need to look into this points and see who would be able to benefit from that protection. Okay, quickly, features of BATs. Scope of application, I said earlier, BATs can, the scope of application of a BAT can be pre-investment or post-investment, depends on the BAT. And the other feature, when we look into the scope, when you read into the scope provision, is you need to look into when the BIT would be able to apply in the country. Is it after the BIT was signed, that immediately it comes into force, or after it was ratified, that the BIT would come into force? So again, there are variations in different BITs when they look into. Some say that as soon as it's signed, then it becomes effective. Some say it becomes into force after it's been ratified. And some also extend the protection of a BIT even before the BIT came into effect. It may even apply to investors that have invested prior to the BIT being signed. These are quite gracious and generous BITs that most developing countries would like to have, and a lot of the BITs. But those countries that have a very strong legal team and legal advisors would push to have the scope of application of the BIT only to apply after the country has signed on and after the BIT becomes effective. So when you look into the UNCTAD website, you'll see the list of BITs that Ethiopia has signed on to. Some are fully enforced, they've been signed and ratified. Some have been signed, but they have not been ratified. So whether the BIT applies to these investments or not, we will need to look into the scope of application of the BIT and whether on the ground practically Ethiopia has gone through the ratification process. Duration of BITs, again, there are variations. Typically, they're between 10 and 15 years. But again, this differs. Some BITs, I think the biggest we have is with Kuwait, that is for 30 years. We have one BIT with Finland, that's for 20 years, and with Russia for 15 years. But typically, it's 10 to 15 years. We have also some BITs that are less than 10 years. There's one, I think, that only lasts for 5 years. But the range is 10 to 15 years. But investors would want as long a protection as they can manage, and usually would push for a longer duration. But typically, it's 10 to 15 years. But then the next question, so what happens after the 10-year period expires, or the 15 years expires? So this is also determined on the BIT. Some BITs would say that one pointing why termination is important is because during the duration of the BIT, states cannot terminate unilaterally. Unilateral termination to BITs is not allowed. So therefore, once the duration expires, the way the renewal happens is different from BIT to BIT. So some BITs would say that it automatically renews for the same duration. For example, if it's a 10-year, it automatically renews for another 10 years. However, states would have the right to terminate. It's not like the first round of the BIT. In the second round, the renewal, state would still have the right to terminate. This is called the anytime termination clause. The second one is the end of the term termination clause. This is quite restrictive, and many countries would not opt for this type, which says that once the first 10-year period ends and the second round comes, it would have the same rules as the first one, meaning still countries will not have the right to unilaterally terminate until the second phase ends. It's quite restrictive, so also the termination clause is an important part of the BIT to refer to. And the other one that is linked, the other clause that is linked with the termination clause is the survival clause. The survival clause means those investors that have invested during the period of the BIT would still have protection for an additional years. It could be 5 years, it could be 10 years. So the protection would extend for those existing investors that have invested during the duration, the active duration of the investor would be extended. Those that have not invested while the BIT was valid will not be able to find the protection. That's for the survival clause. So it's something that you need to look into when you look into the BITs. What are the termination terms? How can countries terminate? What are the renewal terms? And also whether there are any survival clause for those investors that have existed, that have invested during the BAT. Standards of treatment. We discussed this in depth last week. National treatment, MFN, fair and equitable, and compensation. All of them you can find in various degrees within the BATs that Ethiopia has signed. Some BATs include national treatment, while others don't. For example, the BAT we have with South Africa and Spain has a very favorable national treatment clause. The South African BAT, if you look at it, it has, when it talks about the national treatment, it talks about absolute equality of investors between South Africa and Ethiopia. Whereas other BATs that we have, say, with Russia and Sudan, have no national treatment clauses at all. So there's no really consistency on how national treatment is treated within the BATs that we have signed. And there is also, like the one example that I gave on South Africa, which offers an almost absolute equality between the investors. In other BATs we've seen, yes, there is a national treatment, but it's qualified. Meaning, for example, some of the BATs we have with other countries, yes, will be a national treatment of investors, the same as the Ethiopian investor, but it has to be, the investment has to be in similar situation, and the circumstances have to be similar. So it qualifies the national investment in a sort of a restrictive way by stating that the investors, the investment has to be similar and the situation has to be similar. You should note that when we talk about national treatment and MFN treatment, we're always comparing, right? So if an investor is invoking a treatment under the national treatment, it's comparing itself with the national or domestic investors. When an investor is invoking the MFN principle, it is comparing itself with another foreign investor. So there's always that relative and comparative standard that would be employed. So therefore, when some of the BATs talk about the national treatment, they say that the investor that is invoking the national treatment has to compare itself with another investor, the domestic investor, that is in a very similar circumstances and in similar conditions. So this sort of qualifies how national treatment will go. Similar with the MFN, MFN treatment, a lot of the BATs have MFN clause. Again, MFN is relative and needs comparison with other investors. In Ethiopia, it adopts different clauses. The way maybe Martha, when Martha comes, she should share with us why we have not had a standard clause for a lot of our BATs. The way it's drafted is quite different, and the protection that is offered to investors is different. So when the MFN treatment is entertained in our BATs, it gives to all investments, to some investments, and also the MFN might also extend to dispute resolution. So dispute resolution is very important for MFN because it requires that the treatment that one foreign investor gets in one BAT is also reflected in another BAT that in another situation in which that foreign investor has opted for dispute resolution. In dispute resolution, it determines whether that foreign investor opted for exit or opted for the UN system or opted for local arbitration. So when you try to use the MFN system in dispute resolution, you see that there's a lot of variation within the BATs. And the other thing is, most of the time, national treatment and MFN are linked together, meaning that countries, a lot of the BATs offer this as a combination, that investors would be entitled to both national treatment and MFN. As I said, in other cases, there may be a case where national treatment is not offered, but MFN is offered, and in other cases where MFN is offered, but national treatment is not. So, but in most cases, there is a combination of national treatment and MFN together. Fair and equitable treatment, which we discussed, national treatment and MFN treatment are subjective standards, meaning that they're compared between two investors that are on the ground. But fair and equitable treatment is an objective standard. It's something that is examined on its own merit. Whether an investor has been treated fairly and equitably is something that will be examined on its own. And many of the BITs that Ethiopia has signed on has this fair and equitable treatment. And the way it's qualified is different. To a large extent, it simply says that investors have the right to be treated fairly and equitably. And if there's any dispute, this means that if there's any dispute that arises out of this clause, or if an investor invokes this clause, whoever is entertaining that that dispute would look into the investment and its fairness and equitability on its own terms, using standards that are normally applicable in any interpretation of the law. In some BITs, it would say, it would qualify it, saying investments should be protected fairly, should be subject to fair and equitable treatment based on international law. So not on its own terms, not objectively, but based on how international law understands fair and equitable standards. We have some BITs, I think one or two BITs that has this clause, but for most part, Ethiopia's BITs does not have this qualification. So this would bring us into, so what does international law say on fair and equitable treatment? Which law are we going to apply? Is it customary international law, or is it conventions that we're going to invoke? So those entertaining this, the dispute would have to look into the international law. This is something that is normally pushed by developed countries, because we know the international minimum standards or the customary international law as it is understood favors the developed countries. The developed countries would want to insert in the clause in the BIT a clause that states that fair and equitable treatment should be interpreted in accordance with international law. But then again, there are variations, and some do not qualify at all. So when you look into the the BITs, also good to assess whether the fair and equitable is qualified or not. If it's qualified, how is it qualified? Is it based on international law? Or some countries may even say that fair and equitable treatment based on the national laws. The third one is nationalization and expropriation. Quickly to go through this. On the expropriation part, to a large extent, a lot of the BITs have adopted the Hull formula, which we discussed last time. Yes, countries can expropriate. They recognize that countries can expropriate, but they need to fulfill a certain grounds. The condition of a public purpose is the fact that there is a due process, and it was done in accordance with the law of the national country, the national state, and there is a compensation formula that is adequate, effective, and just. To a large extent, there are some variations, very minor variations, but to a large extent, BITs have adopted the Hull formula. And also the way we understand expropriation and nationalization, how is it defined? The definition would also have to be looked into. When you talk about expropriation, usually it involves the direct taking of property by the state for purposes of its own or for public purposes. But there are also other measures that do not involve direct taking, but that may constitute expropriation. For example, if an investor, if its license is suspended, the property was not taken, but the government looked into the case and suspended the license of the investor, would that constitute an expropriation? Would that constitute as indirect expropriation? Or say, if the government increases the tax, heavily taxes that specific sector, and in which case that investor was not able to perform or does not make a commercial sense and is forced to abandon its investment and goes back to its country, would that constitute as an expropriation, as indirect expropriation? How do we understand expropriation? Simply beyond direct taking or direct takeover of a property. So this is also something that you see in the BITs that you read, that some BITs say expropriation as defined by the national laws. So they refer, the definition, the definition to the national laws. And some are quite expansive and have a very detailed understanding of what expropriation is. It includes direct taking over, indirect having the impact of an expropriation. You will see that how there are a bit of a negotiation and a compromise on how expropriation and nationalization is understood. And also, once the definition of expropriation is determined, and also how compensation would be determined. When we look into the BITs, the compensation, like I said, in general adopts the whole formula, but when it talks about the adequate compensation, it uses very different forms. Some BITs use the word adequate, some say fair compensation, some say market value, the market value of the property that was expropriated. Some say the fair value of the property. So there are different variations there, but to a large degree they mean that the compensation should be paid on the basis of the property that was taken over. Finally, dispute resolution, the last point. I don't know if Martha's here already. Final point, dispute resolution. So disputes can happen at 3 levels. One is between the states. There are the BITs signed between say Ethiopia and Kenya. There could be an investment dispute between the state of Kenya and the state of Ethiopia as investors, because states invest in their own countries. So there could be a dispute between those 2 states. And the second one is between the state and the investor. So the investor has invested in the state takes some measures, and the investor has a dispute against the state. And the third one is between 2 different investors, private to private. And dispute resolution, and when you look into the BITs, you see that it is sort of divided into stages. If there is a dispute between any of these actors, state to state, state to investor, or even investor to investor, most BITs would recommend that they take first amicable resolution to the dispute. It would give time from 3 to 6 months, some even longer, for the parties to come in and amicably solve their dispute before they can trigger any dispute resolution mechanisms. Mostly for state-to-state disputes, what's done is that diplomatic channels are preferred, using diplomacy to solve the issue. For state-to-investor, they would say amicable negotiations and consultations to be pursued. The same for investor to investor. So when that period expires, 3, 6, or 9 months, then you can trigger the dispute resolution mechanism that is embedded in the BIT. It could be arbitration, or it could be national courts. Again, a lot of the BITs have different variations of this dispute resolution and how Ethiopia may pursue it. You'd also note that when you read